Oh, hello. Welcome to my bar review show. Today we're talking about wills. Wills involve intestacy, construction of a will contracts, execution of a will, revocation of a will, transfer power, probate and administration, contest, and appointment and attorney power. So you have intestacy, construction, will contracts, execution, revocation, transfer power, probate administration, will contest, and power of appointment and power of attorney. Intestacy. We'll talk about it generally. We'll talk to surviving spouse. Then we'll talk about issue. Issue as far as generally, as far as the parent and child relationship, and then as far as calculating share. Finally, we'll talk about ancestors and remote collaterals. All right, intestacy generally, the UPC. We have surviving spouse takes the entire estate. All of decedent's descendants are also surviving spouse's descendants, and surviving spouse has no other descendants. Decedent has surviving spouse, but no descendants or parents. Surviving spouse takes $300,000 and 75%. No descendant of decedent survives decedent, but decedent has surviving parent. Surviving spouse takes $225,000 and 50%. All of decedent's issue are also surviving spouse's issue, and surviving spouse has other issue. Surviving spouse takes $150,000 and 50%. Decedent has issue not related to surviving spouse. Community property. All property acquired during marriage is jointly owned by both spouses, unless property is gift, inheritance, or devise given only to one spouse. Community property is divided equally. Surviving spouse owns 50% outright. If decedent dies intestate, decedent's 50% of common property given to surviving spouse, and decedent's separate property distributed pursuant to general intestacy scheme. Surviving spouse. Marriage requirement. Surviving spouse must have been legally married to decedent. Putative spouses. They qualify if spouse believes in good faith and invalid marriage's validity. Separation. Spouses are still married until final dissolution decrees issuance. Survival requirement. Surviving spouse or other heir must survive decedent to inherit or take under the will. Common law. Surviving spouse must have survived decedent for any time length. USDA, which is the Uniform Simultaneous Death Act, they have the 120-hour rule. Surviving spouse must have survived decedent by 120 hours, 5 days. Insufficient evidence of death order. Each individual's property passes as though other individual predeceased her. Death's determination. Common law. Irreversible cessation of circulatory and respiratory functions. The modern standard is brain death, for which there are no established criteria. Proof burden on the party whose claim depends on survivorship. At common law, evidence preponderance, Uniform Simultaneous Death Act, clear and convincing evidence. Issue generally. All lineal descendants, including children, grandchildren, great-grandchildren, etc. All lineal descendants, including children, grandchildren, great-grandchildren, etc. Issue parent and child relationship. We have married parents, adopted child, foster parents and step-parents, half-bloods, children born out of wedlock, posthumously conceived child. Married parents, child of marriage. The presumption is child is marriage party's natural child. Posthumously born children, there's a rebuttable presumption. Child is deceased husband's child if child is born within 280 days, 9.3 months of the father's death. Adopted child. Reference in will to kid includes adopted kid. Treated like biological kid for inheritance purposes. No inheritance rights between genetic parents and adopted kid. Step-parent exception. Step-parent adoption establishes parent-child relationship between step-parent and child with full inheritance rights, but does not curtail the parent and child relationship of the genetic parent who is married to the step-parent, nor right of adoptee or adoptee's descendant to inherit from or through the other genetic parent. Foster parents and step-parents. Generally, no inheritance rights between child and foster or step-parent. Equitable adoption. Relationship started during child's minority, and legal barrier prevented adoption, established by clear and convincing evidence. Or foster agreed with genetic parents to adopt child and foster treated child as his own. Effects. Child can only inherit from, not through, equitable adopted parent. Equitable parents cannot inherit through or from child. Inheritance rights between child and genetic parents is unaffected. Half-bloods. Treated same as whole bloods. Children born out of wedlock. The modern trend. Cannot inherit from natural dad unless dad subsequently married natural mom, dad held kid out as his own and lived with kid or provided support, paternity is proven by clear and convincing evidence after dad's death, or paternity is adjudicated during dad's lifetime by evidence preponderance. UPA, Uniform Parentage Act, requires paternity proof for child to inherit. When father holds child out as his own, paternity presumption. Child can bring action to establish paternity at any time. Otherwise, no paternity presumption. Child must bring action within 3 years of reaching age of majority. Posthumously conceived child. Not recognized as deceased parent's child. Issue, calculating share. We have per capita with representation, per stirpes, per capita at each generation, and negative inheritance. Per capita with representation. Property is divided equally among the first generation, with at least one living member. The non-living member of that generation's share passes to that member's living issue. Non-living member with no living issue no property is allocated to non-living member. So the non-living member gets nothing. The dead member, 1/2 of his membership goes to the siblings together. And then in this scenario, 1/2 goes to the living sibling. All right, for Stirpes. Issue equally share portion deceased ancestor would have taken if living. Estate first divided into ancestor's total number of children who survive or leave issue who survive. Grandpa dies at 102. Grandpa had 3 kids. This lady, this man, and this other man, who each had kids of their own. See, look, there's grandkids, grandkids, and grandkids. Unfortunately, his daughter predeceased grandpa. So these are the folks who will inherit at grandpa's death. Per capita at each generation. Property is divided into as many equal shares as there are living members of the nearest generation of issue, and deceased member of that generation with living issue. Negative inheritance. To disinherit heir through properly executed will. All right, ancestors and remote collaterals. There's 3 approaches. Ancestors and remote collaterals are when no surviving spouse or when no surviving spouse or descendant exist. That's when we have ancestors and remote collaterals. There are 3 approaches: the parentelic, UPC, degree of relationship, and the combined approach. Parentelic, UPC approach follows collateral lines until a live taker is found. Decedent's property is distributed within that taker's parentelic line. So we look through these lines until a live taker is found. So we first have decedent's parents equally if both survive, or all to surviving parent if only one survives. So that's parent goes first to parents. Then to decedent's parents' descendants. That would be your brothers and sisters. Then to decedent's living maternal or paternal grandparents. So living grandpa, living grandma. Then decedent's deceased grandparents' descendants. So if grandma or grandpa is dead, then it goes to your aunts, your uncles, or your cousins. Then decedent's nearest maternal or paternal relative, kind of general. And finally, decedent's estate escheats to the state. Degree of relationship approach. Calculated by counting number of relatives between living taker and decedent, using closest common ancestor. The combined approach. Those in closer collateral line take to exclusion of those in more remote collateral line. All right. Break for a new section. You can pause the video here and come back when you like. All right, we're back. We're talking about will construction. We'll talk about gifts classification system, incorporation by reference, acts of independent significance, lapse, abatement, ademption, and ambiguities and mistakes. Gifts classification system, specific. This is property distinguished with reasonable accuracy from testator's other property. General. Property to be satisfied from general estate assets. Demonstrative. Property from a particular source, but if source is insufficient, then testator directs legacy to be satisfied from estate's general assets. Residuary. Property remaining after all specific, general, and demonstrative gifts are made. Abatement. The order. So, I want you to note that this group of slides is here twice. You'll see it again later because abatement is so important. So, abatement is a gift, reduction, or elimination when assets are insufficient. Gifts abate in the following order. First, intestate property, then residuary bequest or leftovers, then general bequest from the general estate assets, and finally from specific bequest, the Franklin stove. Note, demonstrative gift is treated as specific. If it cannot, then it is treated as general. Incorporation by reference. Another writing not executed with testamentary formalities may dictate testator's property distribution if it existed at the time of will's execution, is intended to be incorporated, and is described in will with sufficient certainty to permit identification. Acts of independent significance. Designation of beneficiary or disposition by reference to some unattested act or event occurring before or after will's execution or testator's death, if act or event has some significance apart from the will. So unattested means not existing in any documented form. Lapse. If beneficiary dies before testator, gift lapses and passes to residuary beneficiary, or if none, via intestacy. Anti-lapse statute. If beneficiary was testator's relative and left issue, then issue succeeds to beneficiary's gift. Applied to class gifts. UPC or modern trend also apply to non-probate transfers. Residuary lapse. Anti-common law. Lapsed residuary interest passes by intestacy. No residue of residue. UPC. Lapsed residuary interest passes to remaining residuary beneficiaries. Void gifts. A gift to a beneficiary who testator doesn't know is already deceased when will was executed. Anti-lapse statute also applies to void gifts. Abatement. This slide group is here twice. We saw it before because abatement is so important. Abatement is a gift, reduction, or elimination when assets are insufficient. Gifts abate in the following order. First, intestate property, then residuary bequest or the leftovers, then general bequest from general estate assets, then specific bequest, the Franklin stove. Note, demonstrative gift is treated as specific. If it cannot, then it is treated as general. Ademption. Gift's denial to beneficiary because property is no longer in testator's estate. Ademption by extinction applies only to specific bequest. The traditional approach, identity theory. The UPC approach, intent theory, mild presumption against ademption. Exoneration of liens, common law. Encumbered real property's beneficiary can have lien paid off. Most states, the UPC, encumbered real property's beneficiary is not entitled to have the lien paid off. Ademption by satisfaction. Gift may be satisfied by inter vivos during life property transfer after will's execution, if that is testator's intent. UPC presumes no ademption by satisfaction absent express writing. Ambiguities and mistakes. Plain meaning rule. reluctance to disturb will's plain meaning regardless of mistake. Ambiguities can be resolved by extrinsic evidence. Mistakes. Extrinsic evidence is admissible to show mistake in will's execution existed. Construction rule. Will speaks at testator's death time. Conditional will. If possible, will's validity is conditioned on event. Then courts will construe excess language as mere explanation rather than validity barrier. Break for a new section. You can pause the video here and come back when you like. All right, we're back. Now let's talk about will contracts. Right, what involves a writing requirement, a consideration requirement, enforceability, and reciprocal provisions. Writing requirement. Will states contract's material provisions. Terms are contained in the written contract, or the will expressly references contract's extrinsic evidence, or will expressly references contract and extrinsic evidence proves the contract's terms. Consideration requirement. Example. Beneficiary promises to care for testator in exchange for bequest. Enforceability. Only if signed by party sought to be charged. No remedy for breach while testator is still alive. Reciprocal provisions. Joint wills. Single instrument that serves as more than one person's will. Does not by itself create presumption of contract not to revoke. Reciprocal wills. Identical reciprocal provisions in separate wills. Does not by itself create presumption of contract not to revoke. Contract not to revoke. If evidence establishes, contract becomes irrevocable on first party's death. Constructive trust is imposed on property transferred by second party in contract's violation. Break for a new section. You can pause the video here and come back when you like. All right, let's talk about execution. Execution involves formalities, holographic wills, self-proved wills, non-cupative or oral wills, codicils, and will substitutes. We got to memorize these next slides. All right, formalities, valid will requirements. You need a writing. You need it signed by the testator. You need 2 or more witnesses. And testator has present testamentary intent. Again, writing, signed by testator, 2 or more witnesses. Testator has present testamentary intent. Again, writing, signed, 2+ witnesses, present testamentary intent. All right. Testator signed writing. Entire will must be in writing. Can be handwritten if signature and witness requirements are met. Testator signed. Signature's location. Some states at end or will is invalid. Other states UPC anywhere, but whatever portion after signature is invalid. Signature's form. Testator's formal name is not required if the name used indicates testator's interest. Signature on testator's behalf. Permitted by person in testator's presence and at testator's direction. Testator's capacity. Testator must be at least 18 and of sound mind. Testator meets mental capacity if she knows her property's nature and extent, persons who are testator's bounty's natural objects, disposition she's trying to make, and testamentary plan. All right, let's talk witnesses. We've got the number, signatures, knowledge of instrument, age and competency, and the interested witness doctrine. Number, at least 2. Some states require 3 witnesses. Signatures, testator signed, or, if on testator's behalf, in 2 witnesses' joint presence. UPC, testator may acknowledge his signature to witnesses. Witnesses need not be present at the same time. Signed by 2 witnesses. No need for attestation clause. Witnesses need not sign at the end of the will. Witnesses must sign in testator's presence. UPC. Witness may sign within reasonable time after witnessing testator sign or acknowledge will. Presence. Line of sight or traditional test. Testator and witness must be aware through any sense each is signing a will. Conscious presence or the modern test. Testator and witness must be aware through any sense each is signing a will. Knowledge of instrument. Witnesses must be aware instrument is will, but need not know about its contents. Age and competency. Witness has sufficient mental capacity or maturity to comprehend value or act of witnessing. This is determined at the signing time. Interested witness doctrine. Witness who receives gift under will. The common law, an interested witness is not competent as witness. Will is invalid unless at least 2 disinterested witnesses exist. Purge theory. Gift to witness denied to extent of amount in excess of witness's intestate rights. UPC. Interested witness doctrine is abolished. Testamentary intent. Testator must execute will with present testamentary intent, must understand he is executing a will, and intend will have testamentary effect. Testator must generally know and approve of will's contents, but need not understand all the provisions. Integration. Will consists of all pages present in execution and intended to be part of the will. Compliance with statutory requirements, common law, strict compliance. UPC, substantial compliance if clear and convincing evidence of testator's intent exists. Holographic wills. Handwritten document. Some states, entire will must be in testator's handwriting. Other states, the UPC, only material provisions must be in testator's handwriting, filled in printed form. Must be testator signed. Proxy is not permitted. Witnesses are not required. A date is required by some states. Testamentary intent. Some states, established by reference to will's printed parts or by extrinsic evidence. Handwritten changes after will is completed are effective. Self-proved wills. Testator acknowledged and witnesses affirmed the will before a court official. Effect. Removes the need for attesting witness's testimony at formal probate proceeding. Non-cupative oral wills. Most states they're not permitted, but some states they are permitted, but they're valid for a disposition of limited personal property made in immediate death's contemplation. Codicils. These are changes or additions to will. Execution. They have the same formalities as for a will. Codicil's execution, they have the same formalities as for will, must be observed. A codicil requires the same formalities as for will. Same formalities as for will must be observed. Good Lord. All right, effect. Republishes will as of date codicil was executed. May validate invalid will. Will substitutes. Methods of transferring property outside probate. We've got revocable trust, pour-over wills, bank accounts and securities registered in a beneficiary form, a payable on death clause in a contract, life insurance, deeds, and finally Totten trusts. So first we have revocable trust. Then we have pour-over wills. These are a devise of testator's property to trust created during testator's life. Bank accounts and securities registered in a beneficiary form. Payable on death clause and contract. Life insurance. Policy proceeds are not part of decedent's estate unless payable to the estate as a beneficiary. Deeds. Unconditionally delivered to grantee during decedent's lifetime or delivered to escrow agent during decedent's lifetime with instructions to turn over to grantee on decedent's death. Some states allow transfer on death deed. Does not require will formalities. Totten trust. Revocable trust type set up with bank, like a payable on death account. Break for a new section. You can pause the video here and come back when you like. All right, we're back. Let's talk about revocation. Revocation involves any time prior to testator's death, lost wills, codicil's revocation, and revival. Any time before testator's death, subsequent instrument. Oral revocation of will does not affect will. Revocation can be expressed or implied by subsequent instrument's terms. Revocation can be expressed or implied by subsequent instrument's terms. Later document controls and revokes prior inconsistencies. Destruction with intent to revoke. Destruction. Burning, canceling, tearing, obliterating, or destroying material portion of will. Most states require some will language defacement. Some states, the UPC, destructive act needs only affect some will part. Rebuttable presumption of revocation. When will once known to exist cannot be found. Inapplicable if duplicate original is found. Executed will's destruction. Presumptively revokes all other duplicate originals. Third party can revoke for testator if third party can revoke for testator if done at testator's direction and in testator's conscious presence. Operation of law. Divorce. Most states, UPC, revokes will provisions for former spouse unless contrary to testator's intent. Some states revokes will provisions for former spouse if property settlement agreement exists. Partial revocation. Permitted, but if revoked gift falls outside of residuary revocation, it is not given effect until will's re-execution or republication. Cancellation of words. Canceling attested words in will can decrease but cannot increase gift. Lost wills. Duplicates or copies. Duplicate original is permitted, but not a photocopy. Proponent's burden. Proof by clear and convincing evidence. Codicil's revocation. This revives the will. Contrast, will's revocation revokes all codicils to will. Revival. Republication, implied. Common law. Original will's automatic revival on subsequent will's revocation. This is followed in just a few states. UPC. Look for testator's intent based on whether second will is revoked by act or by later will, and if second will is revoked by an act, whether first will was wholly or partially revoked by that second will. Second will revoked by another new will. Previously revoked will only revived if new will's terms show testator intended previous will to take effect. No extrinsic evidence. Second will revoked by a physical act. Extrinsic evidence is permitted. Whole revocation. The presumption is testator did not intend to revive the first will. It's the first will's proponent's burden. Partial revocation. The presumption is testator intended to revive previous will's revoked parts. First will's challenger's burden. Express. Testator acknowledges original will with testamentary formalities. Dependent relative revocation. Testator's will revocation disregarded if it was based on law or fact mistake, and it would not have been done but for that mistake. Break for a new section. You can pause the video here and come back when you like. Transfer power. We'll talk about surviving spouse's rights, gifts to children, omitted child, and bars to succession. Surviving spouse's rights. Elective or forced share in a common law state. Surviving spouse can elect to take share of testator's augmented estate rather than gift left to surviving spouse in will. Right may be waived by signed writing after fair disclosure before or during marriage. Community property state. Surviving spouse is entitled to 1/2 of community and quasi-community property, forced share. Surviving spouse must elect to take forced share in lieu of any interest under testator's will. Omitted spouse. Spouse who married testator after testator's will was executed and who is not will beneficiary. Rebuttable presumption omission was mistake. Omitted spouse is entitled to an intestate share. Traditional doctrine. Presumption is rebutted if testator's intent to omit spouse is apparent from will's language, or if spouse was provided for outside of will. UPC. Valid prenuptial agreement also rebuts presumption. Gifts to children. Inheritance advancements. Correspond to redemption by satisfaction for gift by will. Common law. Lifetime gift is presumed child's intestate share advancement. Child has burden to prove otherwise. The modern trend, or UPC, gift is advancement if decedent declared in contemporaneous writing, gift was advancement, or heir acknowledges gift was advancement in writing. Controlled transfers to minors, guardianship, conservatorship, transfer pursuant to Uniform Transfers to Minors Act, or trust. Omitted child. Child born after testator's will is executed. Rebuttable presumption. Omission was mistake. This presumption is rebutted by intentional omission. Testator had other children when will was executed, left estate to omitted child's other parent, or testator otherwise provided for child. Omitted child share. Testator's only child gets an intestate share. Other children. Omitted child shares equally in property devised to other children. Bars to succession. Homicide. Decedent's killer cannot take under decedent's will or through intestacy. Killer is treated as if killer predeceased decedent. Disclaimer. Allowed, but must be affirmatively done because gift acceptance is presumed. Disclaiming party is treated as if she predeceased decedent. Break for a new section. You can pause the video here and come back when you like. All right, let's talk probate and administration. Probate property is property that passes under testator's will or by intestacy. We'll talk about the procedure. We'll talk about creditor's claims, the personal representative, and the fiduciary duty. Procedure. Jurisdiction. Decedent's domicile at death time has jurisdiction over decedent's personal property and any real property located there. Notice is given to interested parties. Timing. The common law, will could be probated at any time. UPC, probate proceedings must be brought within 3 years of death. Creditor's claims. Period of limitations. Claim must be made within specified period after probate is opened. Notice. Personal representative must provide creditors with notice. Priority of claims. First, administration expenses. Second, last medical expenses and funeral expenses. Third, family allowance. Fourth, tax claims. Fifth, secured claims. Sixth, judgments against decedent. And seventh, all other claims. Personal representative. The administrator is court appointed. The executor is named in the will. Priority for appointment. Person named in the will, surviving spouse who is devisee, other devisees, surviving spouse, other heirs, and finally, any creditor 45 days after death. Principal duties. Notify legatees, heirs, and claimants. Inventory, collect, and manage decedent's assets. Receive and pay creditors and tax collectors' claims. Distribute remaining assets. Fiduciary duty. Owes the highest loyalty and care duty to those represented. Common law. Can be personally liable for estate's actions. The UPC can only be sued in rep capacity for fiduciary duty breach. Break for a new section. You can pause the video here and come back when you like. All right, contest. Will contest. We'll talk standing to contest, testamentary capacity lack, insane delusion, undue influence, fraud, forfeiture charge, restraints on marriage, and conflict of laws. Standing to contest. Only directly interested parties who stand to benefit financially may contest will, not testator's general creditors, nor spouse or prospective heir of beneficiary under a prior will. Testamentary capacity lack. Testator lacks capacity if, at will's execution time, testator did not have ability to know act's nature, his property's nature and character, his bounty's natural objects, and attempted disposition plan. Insane delusion. A belief for which no factual reasonable basis exists, but to which testator adheres, despite all reason and contrary evidence. Rational person test. Rational person in testator's situation could not have reached the same belief. But for causation. Delusion was sole cause of testamentary disposition. Undue influence. Third party exerted mental or physical coercion on testator with intent to influence testator such that testator loses control of testator's own judgment and executes an unnatural will. Confidential relationship. Testator confided, trusted, or relied on other party because of weakened or dependent state. No confidential relationship between husband and wife. Beneficiary's proof burden to show, by evidence preponderance, no undue influence existed. Beneficiary is treated like he predeceased testator to extent gift exceeds beneficiary's intestate share. Fraud. Beneficiary made misrep. Beneficiary made misrep when will was executed. Fraud. Beneficiary made misrep when will was executed with intent to deceive testator and with purpose of influencing disposition, resulting in a will that would not have been executed but for fraud. Forfeiture clause. Designed to deter beneficiary from suing over his share by causing him to lose his share entirely if he does so. UPC in most states find forfeiture clauses unenforceable against beneficiary who has probable cause to contest. Restraints on marriage. Provisions imposing gifts forfeiture if beneficiary should ever marry. Provisions imposing gifts forfeiture if beneficiary should ever marry are invalid and against public policy. Conflict of laws. Validity under UPC determined under law of place where will was executed, or testator is domiciled. Break for a new section. You can pause the video here and come back when you like. All right, let's talk power of appointment and power of attorney. These involve powers of appointment and powers of attorney. Power of appointment. The power to decide to whom property is given. There's two types, general and special. General power of appointment. No restrictions or conditions on powers exercised. Special power of appointment. Places limitations on holders' exercise of power. Authority scope. Exercising power. Any instrument may be used to exercise power, unless donor directs otherwise. Contracting the power. Holder can contract power if presently exercisable power. Testamentary appointment power can only be exercised via will. Mere residuary clause in will is not sufficient to exercise power, but use of phrase, including any power of appointment I may possess, is sufficient to exercise power. Powers of attorney. Types. General power of attorney. Agent can handle all affairs when principal is unable to do so. Special power of attorney. Agent's powers are limited to specific function or duration. Authority scope. Durable power of attorney. Agency continues until principal's death, even if principal becomes incapacitated. Majority of states presume power is durable. Fiduciary duties. Liability. Agent is only responsible for intentional misconduct. Revocation. Powers can be revoked by principal at any time. And we're done. Congratulations, you made it through wills.